So South Dakota versus 15 impounded cats is a real court case. I'm here to talk about it. So in 2010, a woman was backing out of a parking spot and nearly hit a cop patrol car. To be fair, the owner of the convenience store called the police on the woman and the cop pulled up right behind her, kind of blocking her in. Now, this woman was living in her car with 15 cats. On the ground of poor sanitary conditions, the officer impounded each and every one of her cats. It wasn't just living in a car, obviously, that was the reason for impoundment. He claimed that there was a full litter box and a strong pet odor. The officer observed no kennels or other suitable and safe methods for pet transport. Edwards, the woman, said they were sprayed and neutered, but the cats destroyed those records, so there's no proof of that. The car was so cluttered that the cats were able to walk around at such heights that it would impair Edwards' vision while driving, which is dangerous if you didn't know that. The driver obviously didn't like that her cats were being impounded, and she challenged the seizure in court. The courts were actually planning on having the cats being transferred to a humane society to be adopted by third parties, and were denying her the ability to claim her pets back. So here are the questions for you. Were Edwards' constitutional rights violated by the impoundment of her cats? Was there enough evidence to support the impoundment of her cats? And was her right of due process violated by being denied a lack of adequate notice of the hearings of this matter? At the South Dakota Circuit Courts, the judge stated that her loss of cats was lawful due to them interfering with her view and safe driving.
I'll allow it.
And she called this exigent circumstances. Now, Edwards hadn't had enough yet, so she appealed to the South Dakota Supreme Court, stating that the seizure was done without providing her due process, which is the Fifth Amendment's work, and for seizure being done without supporting evidence, like it's a language arts test. This connects to the Fourth Amendment. She argued that there was plain error, which means that this affected her substantial rights during this process as prejudice occurred. This is different from harmless error, where yes, an error did occur, but her substantial rights were not violated. But she claimed plain error, not harmless error. So legally, for a warrantless impoundment to occur, like in Edwards' case, an animal has to be either severely injured, severely diseased, suffering, and any delay in impounding the animal would continue to cause the animal extreme suffering, and other exigent circumstances existing. The officer claimed that this, other exigent circumstances, was the reason for the warrantless impoundment, and that it did not violate her constitutional right to no unlawful searches or seizures, as protected by the Fourth Amendment. Another reason for the impoundment were the safety risks, not just for cars, but they claimed the public was at risk as well, due to Edwards driving in unsafe conditions, because having 15 cats roaming around your cluttered car is not safe. The interaction between Edwards and the officer occurred on an August 9th as she nearly backed into his car, which isn't something like a little moped. It's an actual police car, which is huge and usually very visible. However, she did not see it. What if this was a little moped or something a little less visible, like a child, for example? This makes her situation a huge safety concern. Now, she argued that this wasn't exigent circumstances because she was not issued a citation by the officer. But this was shot down because of the legal precedent set by a court case, Tipton versus Town of Tabor, where part of the decision includes law enforcement entails more than simply reading to violations. It encompasses the art of keeping the peace. And that's what this officer was doing, keeping the peace. Because had she backed into a child or done something that was also very, very dangerous while driving, the peace at the busy convenience store or in the area would have not have been kept. Now let's talk about due process, and was Edwards' right to due process violated during this case? Generally, people are entitled to due process when their protected property, in this case the cats, are being deprived from them. It's a requirement of the process to be given notice, the right to be heard in a meaningful time and manner, meaning that she cannot wait 10 years to talk about this case. And this also means that they cannot do the case on Bourbon Street in New Orleans or in her disgusting car. Now, Edwards was present for both hearings, and she did not object nor complain to the notice provided before. At the first hearing, the circuit court made numerous comments to her about coming back with an attorney, consulting with the legal counsel, or to actually prepare a defense on why she should get her cats back, because she didn't do that. So yeah, that's pretty irresponsible. She just thought she could just walk in and it would be right there for her to take home, and that would be all, folks. The information kind of waves away her argument that she was denied due process. When she brought up plain error, as I mentioned previously, she failed to demonstrate prejudice, which was a requisite of plain error, as per South Dakota versus Bowker. There was also no evidence that error occurred in regards to the officer's actions that would have had reasonable probability in changing the course of the case, meaning that the same results would have occurred no matter what. She also never contested nor disrupted any matters that were brought up in the case, so yeah, plain error did not occur. Now, I do need to say again that this was all brought up before she appealed to the South Dakota Supreme Court, as the Chief Justice at the time, David Gilbertson, rejected the case, finding the officer's actions lawful and didn't see anything that should be said regarding the case that wasn't already said. Justice Severson did dissent, saying that exigent circumstances was a too vague of a term, and since the vet said that the cats were not in poor health, the situation did not qualify as such circumstances. If she was driving in dangerous conditions, she should have been charged with a traffic violation. However, dissents were only a minority, and Edwards' cats were kept legally impounded. And this case remains a precedent for South Dakota state law. And that is the case for you. That is the end of the video. Thank you so much for watching. Please like and subscribe. It really does help me out. Comment down below something. I'll read it. And I'll see you guys in the next video. Adios!